Welcome back. My name is David Nachman. I'm the managing attorney at Nachman and Associates PC, also known as the Visaserve team. One of the areas of immigration law which we get many inquiries about is with regard to family-based immigration law, and that's the immediate relative classification, which is marriage to a U.S. citizen. There are many other immediate relative classifications, and there are other family-based classifications which we'll discuss in additional bloggings. However, the one that we get the most number of inquiries about is marriage to a U.S. citizen. And one of the things that people seem to think is that there's only one way to do a marriage-based case. And that's not in fact correct. So usually what you need to do is a lot of planning to make sure that a family-based case meets the timeline that a potential client is looking for. So what are some of the ways in which a family-based case, immediate relative, marriage to a U.S. citizen, how is that done? Well, one of the ways in which it can be done, or at least the first question that we ask our clients is the individual the foreign national in the United States, or are they outside the United States? So that's really the most important question, and the question that you should be asking yourselves. So for example, let's say you have a U.S. citizen husband who's marrying a foreign national wife, and let's say the foreign national wife is in the United States. Well, the way that type of case takes shape is that if the foreign national has entered the United States and they've entered in appropriate status, and if they are not out of status for a long period of time, a case can be filed in the United States. The way it's done is that a package is filed with the National Benefits Center. The National Benefits Center, the way it's done is that you would file with the Chicago lockbox with the fees. The Chicago lockbox then takes that package, and what they do is they forward it to the National Benefits Center. Then the National Benefits Center forwards that file after they break it apart and process the employment authorization document and the travel document. And then what they do is they forward that to the district office, and that's where the foreign national is notified for an interview. So that's really the most straightforward way in which a marriage-based case is handled. But there are other considerations and other ways in which a marriage-based case can be handled. For example, one way that a marriage-based case can be handled is that an individual could decide that they want to bring in an individual who they're not married to. So that would be what we call a fiancé case. That's a K-1 visa. So a K-1 visa is done whereby the foreign national has met and been with the U.S. citizen within 1 year of the filing date of the fiancé petition. And the U.S. citizen then makes a filing, also with the National Benefits Center, and then sends that K-1 visa to the fiancé abroad. The fiancé then processes their case through the consulate office and then enters the United States. It is required for that type of visa that the foreign national marry the U.S. citizen within 90 days upon entry into the United States, and that then after that you can file an adjustment of status. So that is for the foreign national when they've entered the United States. So that's another way in which a marriage type of case can roll out. There is another option that's available, and that is what's called the K-3 visa. The K-3 visa is one in which the foreign national is in the foreign country, and the U.S. citizen, if he or she is married to the foreign national, can process the K-3 visa also through the National Benefits Center and send the K-3 visa to the foreign national abroad. The foreign national picks up the K-3 visa, enters the United States, and then after entering the United States in this K-3 non-immigrant visa status, can later adjust their status to that of a lawful permanent resident or green card holder in the United States. So those are some of the ways in which a marriage case, immediate relative case, can be handled. A couple of the nuances involved in this type of case is, first of all, whether or not the individual has entered the United States in a non-immigrant visa status. And then there's a question as to whether or not there was some form of preconceived intent as to whether or not they wanted to marry a U.S. citizen, and when, let's say, they entered on a non-immigrant visa, whether that underlying non-immigrant intent contravenes the immediate relative petition. So, for example, in the context of an individual who enters the United States, let's say the foreign national enters the United States on the visa waiver program, and let's say waits only 10 to 20 days before filing a case having married a U.S. citizen when they've entered the United States. Well, in that case, there is a potential risk for the government to come back and say, well, there was a form of preconceived intent. The individual entered the United States as a visitor on the visa waiver program with the intent to marry a U.S. citizen. This issue of preconceived intent can be abrogated by waiting a period of time. Let's say if you go beyond 45 days or 60 days, that might be the safest way to go, because there is this 45, 60-day rule that the Immigration Service recognizes, where that would sort of abrogate this idea of preconceived intent. Now, one of the other practice tips associated with deciding whether or not to go the route, let's say, of a K3 visa, which I mentioned before, or to go the route of a marriage-based case, where you do a filing simultaneously of the I-130 and the I-485, has to do with whether or not the individual, the U.S. citizen who's marrying the foreign national, has the ability to fill out what's called an affidavit of support. The affidavit of support is sort of associated with each one of these immediate relative petitions. If the foreign national, if the U.S. citizen is not able to fill out an affidavit of support for the foreign national, then you may be looking, it may be a better idea to be looking at a K3 visa as opposed to doing an immediate relative simultaneous filing in the United States, because the K3 does not require an affidavit of support to be filed. So that's a sort of a practice pointer on that issue. Our practice is, as I've indicated before, our practice is composed of mostly corporate and business immigration. However, of course, as a courtesy to our business and corporate clients, we do maintain a family-based practice. We do handle on a regular basis marriage to U.S. citizen cases. Part and parcel of those cases, of course, is doing the analysis like the one I've just mentioned and making sure that each of the factors that needs to be considered, such as the affidavit of support, the timing needs of our clients, the logistical needs of our clients, and also, of course, whether or not there are any dependents that would be daughters or sons of the foreign nationals, whether they need to be subsumed within the case. So it's a very important thing, not just to run off and do a filing like this, but really to take into account all of the potential factors and to analyze the case properly. If you have any further questions about any of the family-based immigration classifications, or if you have any questions about a marriage-based case, please feel free to contact us. You can reach our office at 201-670-0006, extension 100 or extension 107. We'll be happy to answer any questions that you might have, or you can feel free to email us at info at Visaserve, V as in Victor, I as in Indigo, S as in Sam, A as in Apple, S as in Sam, E as in Early, R as in Richard, V as in Victor, E as in Early.com, Visaserve.com. We'll be more than happy to get back to you. Thanks very much for your attention, and we look forward to having additional discussions with you.